Okay, so pain and pain disorders. So I'm going to race through this a little bit because it's less pertinent to where it was now, where it was in the past. So this is the setup for it. So in your AMA guides, chronic pain is dealt with in chapter 15. Okay? So chapter 14, the mental behavioral chapter, will clearly specify that in terms of rating pain conditions, they don't get rated within chapter 14 using the method that we've been just talking about. They get rated in chapter 15. And chapter 15 is set up very differently than any other chapter in the guides, in that the preamble to that chapter basically says, that across jurisdictions in the US, it's the American Medical Association guides, there are different jurisdictions, again, WCB as well as in terms of MVA. Some of those jurisdictions readily acknowledge entitlement for chronic pain. Others do not. Okay. In Canada, we have the Morardini decision. Nova Scotia went to the Supreme Court of Canada. There was a WCB from Nova Scotia case. It was in the, I think, early 2000s. And basically, the Supreme Court made it loud and clear that across Canada, one cannot discriminate against genuine bona fide chronic pain. They must have access to all entitlements relative to any other medical/psychological condition. That having been said, we knew that. That having been said, the guides basically told us that we couldn't rate for chronic pain. What the guides say is, instead of providing an actual rating, is you give the adjudicator, whether that's a WCB adjudicator or an MVA adjudicator, a framework so that if your jurisdiction does recognize chronic pain, they have a method of taking your data and then translating it into a chronic pain entitlement. So even though in Ontario the landscape's very clear, and even though all of our other entitlements recognize chronic pain, we have in the SABs for years, we have in our case law for absolutely years, probably 30 years or so. The AMA guides, which is cited in the SABs, basically strong-armed us into not being able to make those ratings. So what we determined was that if we're going to make a chronic pain rating, first of all, the claimant had to have an alternate significant psychological diagnosis. So they had to have a major depression, a post-traumatic stress disorder, generalized anxiety disorder, an agoraphobic condition, something tied to the accident, obviously. And then once we had that, we could then integrate the pain disorder, chronic pain, functional impacts in with the rating of the other major disorder. And ultimately, the argument was, I'll ask my psychologist and neurologist/psychiatrist, gentlemen, can either one of you tease out the functional impact of a chronic pain versus a major depression when you have both occurring simultaneously? No? Yeah, virtually impossible, right? They end up becoming one big ball of stuff. So that's how we approached it. So what was unique about Pastori, again, was after it became clear, after the directive was there in terms of the Charter of Rights being invoked in case law pertaining to the MVAs, it became, I felt, appropriate to invoke it in this kind of situation as well. So that's why ultimately we now have Pastori reflecting and giving us the ability to rate strictly on a pain disorder, even when there are no other psychological full-blown diagnoses being considered.